Hi everyone, this is Mallory Flowers on behalf of Jennifer Shelfs and Associates, and we are coming to you live from Washington, D.C., and welcome to our Webinar Wednesday series. Our webinars are held every Wednesday in 2018 at 12 p.m. and 12:30 p.m. Eastern Time, and our speakers range from accountants to attorneys and other industry professionals. The full schedule for the rest of the year is on our website underneath the webinar tab. In the interest of time, we do not take questions, and our speakers' contact info is posted on the last slide. So if you have any questions, please contact the speaker directly. The recordings are on the website underneath the archived webinar tab as well as on our YouTube channel. And this is just a quick blurb about us. Jennifer Shelfs and Associates is based in downtown Washington, D.C., and we help both product and service companies with federal contracting. Our clients are domestic and foreign, defense contractors and civilian, and our services range from market analysis reports to contract vehicles, including the GSA schedule. We can also help you with proposal writing and post-award contract administration. More information about our services and upcoming events can be found on our website. And this is just a couple of our upcoming events in January that you can find more information on our website. And we are now introducing advertising in our weekly newsletter and in our 2019 Webinar Wednesday series. So just email me if you have any interest or concerns. All right, so we're going to go ahead and dig into today's presentation, which is bid protests in the federal space. And our speaker today is Ed Delisle. You can learn more about his background on this slide. All right, I'm going to go ahead and hand it over to you.
All right, thank you, Mallory. Welcome, everyone, and thank you for joining us today as we discuss bid protests in the federal space. As Mallory indicated, my name is Ed Delisle. I'm a partner at Offutt Kerman. I'm sitting here in Philadelphia. We have offices up and down the Atlantic seaboard. We have offices in Tysons and D.C., and based upon what I do as the chair of the government contracts group at my law firm, I find myself in Washington, D.C. quite a bit, dealing with things like bid protests. So today we will spend about the next 25 minutes or so talking about what it all means. Can you advance the slide? Okay, so as an attorney who operates in the federal space and who assists government contractors with procurement issues, I'm often asked this very question: what is a bid protest? And as you'll see here, it is a statutorily created right to challenge the rules of a procurement, a proposed evaluation, or an award. And what it effectively does is it allows a federal contractor to serve as a watchdog for a government agency to ensure that the procurement process is fair and objective. And when it comes to sort of what this definition means, let's talk about it in some specifics and give a few examples. So when it comes to challenging the rules of a procurement, well, what does that mean? Well, if a solicitation is issued by a government agency, which in a federal contractor's opinion is unclear, or key provisions in it are ambiguous in some way, that could give rise to the need to file a protest, particularly if you are that federal contractor and are interested in submitting a bid or proposal in connection with that solicitation. If a solicitation is unduly restrictive, then that might form the grounds of a protest of some kind. What does that mean? Well, I just dealt with one recently where the agency asked for contractors that have performed 3 projects of similar size and complexity over the course of the last years at the particular facility where this specific opportunity was going to take place. It sounds okay. The only problem was the only federal contractor that fit that criteria was the incumbent. Okay, and the contractor that I represented was not the incumbent, so that formed the basis of a protest. Sometimes the rules of engagement when it comes to a procurement pertain to other legal issues that are important and that could give rise to a protest. For example, if you're dealing with small business issues or requirements and those issues or requirements are not followed, that could give rise to a protest. And what does that mean? Let's talk about an example. If we're talking about a solicitation issued by the Department of Veterans Affairs, for example, and that opportunity has been set aside for a WOSB or a hub zone company, there's a possibility that the VA violated the Veterans First legislation and implementing regulations, which requires the department to set aside opportunities for VOSBs and SDVOSBs first before considering other set-aside possibilities. There's a possibility in a situation like that there could have been an error in how that solicitation was issued, and it could give rise to a protest. And I've dealt with protests many times in the past like that. What about a proposal evaluation and a challenge to a proposal evaluation? Well, if you submitted a proposal for a particular opportunity and you felt or feel that your proposal was misinterpreted in some way, that could give rise to a protest of some sort. For example, if it is a negotiated procurement under FAR Part 15 and the agency provided you with a satisfactory past performance rating, and that was one of the evaluation factors, but you believe that a truly objective review would have yielded an excellent rating, that could be grounds for a protest based upon how the proposal was evaluated. In a situation where an agency uses something as a discriminator in determining how one particular proposal is evaluated versus another, and that discriminator represents an unstated evaluation criteria, that could be the basis for a protest. For example, if the discriminator in a particular opportunity is schedule, a federal contractor tells the agency, hey, agency, I can finish this particular project in X amount of days. Agency likes that. And so agency uses that as the discriminator between that contractor and another. But schedule is not or a stated criteria in the solicitation itself. That could present a protestable issue. Right? So these are all ways in which protests can come about, and these are all examples, the ones that I gave you, that I've dealt with in the past. One of the very important things to understand about protests is the fact that they are creatures of statute, and as a result, you have to know the rules. And in particular, you have to understand the rules that pertain to timeliness in order to preserve whatever rights you may have if you wish to proceed with a protest of some kind. And we'll get into those as we move through our discussion today. Advance the slide, please. So who can file a protest? Well, an interested party can. And what you see here is a definition that's taken from FAR Part 33. And an interested party in FAR Part 33 is defined as an actual or prospective bidder or offeror whose direct economic interest would be affected by the award of the contract or failure to award the contract. So let's break this down a little bit. It's basically two pieces. Part number one, an interested party is an actual or prospective bidder or offeror. Okay, well, an actual bidder or offeror, that's easy. That's a disappointed bidder or offeror. So someone who has submitted a bid or proposal who was not issued an award. That person could be an interested party if they satisfied Part 2, which we'll get to in a moment. The other aspect of Part 1, a prospective bidder or offeror. What does that mean? Prospective bidders or offerors, as it's defined here, means someone who could and is interested in a particular opportunity. So we're talking about a pre-award situation where someone might be interested in challenging the rules of engagement as identified in a solicitation. That would be a prospective bidder or offeror. Okay, so that's Part 1. Part 2, whether you're actual or prospective, you have to have a direct economic interest impacted by the action of the agency. Okay, well, what does that mean? Well, with respect to a prospective bidder or offeror, it's pretty easy. You have to be somebody who would fit within the criteria of a prospective bidder. If it's an unrestricted solicitation, that could be pretty much anyone. If it is set aside for a small business or a small business category of some type, as long as you fit within that category, you would fit the full and complete definition of who an interested party is. If we're talking about actual bidders or offerors, it's a little bit different. To prove that you have a direct economic interest and therefore to be an interested party for purposes of protesting, you have to be next in line, okay, for an award, or you have to argue that the evaluation was such that whoever is in front of you, ahead of you, in line for an award, can effectively be moved aside and allowing you to step forward as being next in line based upon how that evaluation was performed. So you have to be able to jump over and ahead of those that may be in front of you, such that you would ultimately end up being next in line. And it could be in situations like that, you're arguing that the entire evaluation process itself, if we're talking about a negotiated procurement, I see this come up quite often, but you're making the argument that the entire evaluation process itself is flawed, and as such, you are an interested party. Now, when you get into a situation like that, where you're attempting to argue that the entire process itself is flawed, it can become a little bit trickier, and it raises another issue. If you're trying to make a decision, if you are an interested party, as to whether you should protest, you need to ask yourself, okay, well, number one, can I win? Okay, so what is the likelihood of success? How tricky are the arguments? And number two, what will it cost? So can I win, and what will it cost? As we proceed through our discussion here this afternoon, we'll talk a little bit about those concepts depending upon which avenue you choose to take as part of the protest process. Okay, right? So can I win, and what will it cost? Advance the slide, please. So you basically have three choices in terms of where to file. So you have an issue, you are an interested party, now you have to make a decision. Where am I going to file? Your three basic choices are the agency, so you can go to the agency that issued the solicitation and file a protest with the contracting officer. That's option number one. Option number two is filing with the Government Accountability Office, the GAO. That's I would say the most popular option when it comes to pursuing protests. And you also have the option of going to the United States Court of Federal Claims, COPSI. The primary differences between the three in terms of who you would be protesting to, well, with an agency, you see it there, you're protesting directly to the contracting officer who had a hand in the selection process. We'll talk a little bit more about each one of these, including the agency process itself, as we move forward here. But when we think about can I win and what's it going to cost, the can I win question is a little more difficult when it comes to filing with the agency, and we'll get into that shortly. At the GAO, you would be presenting your protest to an attorney at the Government Accountability Office. I mentioned earlier that it's probably the most popular place to file a protest. The GAO receives anywhere from 2,400 to 2,600 protests a year, and that's the average over the course of the last 4 or 5 years or so. That's a lot. Not all of those go all the way through to decision, but I would say by far it's the most popular of the three choices you see here. And the Court of Federal Claims is the protests are overseen by judges. So you have actual judges who listen to arguments, read the documents that are filed, and render actual decisions. I mentioned here the FAA. There are other agencies that have alternative procedures that deal with, when it comes to dealing with protests. The FAA is certainly one, and they have the Office of Dispute Resolution, ODRA, which is particular to FAA procurement. So if any of the folks out there do work with the FAA, be aware that it's a separate process. I sort of like ODRA. I've dealt with them a number of times in the past, and I like it because it has a nice ADR process that I've been able to use. And so if you are working with the FAA, just be aware that it's a little bit different. Advance the slide, please. And what types of protests do we have? Okay, so this is important also. It's important, when we touched on it earlier, but it's important in terms of both timing and understanding precisely when things need to happen. So you have pre-award challenges or protests, and a pre-award bid protest is a challenge to the terms of the solicitation itself. And we talked about examples of that a few moments ago. And you also have post-award protests, where you're challenging the agency's evaluation and/or award decision. So those are your two basic types. If you're in a pre-award context, the key is to make sure, from a timeliness standpoint, that you're submitting your protest before proposals are submitted or bids are submitted. If it's a post-award, we'll talk about some of those time frames shortly, but the decision to protest will be made once the awards are issued. You do have some protests that don't fit neatly or cleanly within one or the other. There are times as part of a negotiated procurement where an agency will create a competitive range, which is done for the purpose of narrowing down the field of potential awardees, right? So sometimes when that happens, a company that is eliminated from competition will want to challenge that, and there's the ability to challenge that. It's sort of an in-between situation because there's no award as such, but you can challenge that if the circumstances permit for it, and if the facts allow it. But there's the ability to challenge the elimination from the competitive range. Sometimes, and it's very similar, you have phase solicitations, and something similar will happen where someone will be eliminated from phase one of a phase two and will challenge the elimination to proceed to phase two. A lot of times, if it's a NAVFAC situation, Naval Facilities and Engineering Command, they call it go, no go. But I just dealt with one of these for a Department of Veterans Affairs cemetery project down in Florida, where it was a phase one, phase two, and there was a very long delay in proceeding with phase two because of a challenge on phase one. So be aware that if you're involved in a phased a solicitation process, that there is the ability to protest under those circumstances. Advance the slide. And what are the deadlines? Okay, these are really important, and you see all the deadlines identified here with respect to agency-level protests. From a pre-award perspective, we talked about this momentarily, a few moments ago rather, you have to submit your protest to the verbiage of a solicitation itself, or the rules identified in the solicitation itself before the due date of bids or proposals. Okay, it's the same thing with GAO. If it's pre-award, the protest needs to be submitted before the due date for proposals or for bids. Post-award at the agency, within 10 days of when a federal contractor knew or should have known of the grounds of the protest. Same thing with respect to the GAO, within 10 days of when you knew or should have known. There's an added factor here at the GAO. If there's a required debriefing, it's 10 days within 10 days after the required debriefing occurs. So it's either 10 days of when you knew or should have known, or 10 days within the required debriefing, whichever is later. That 10-day issue pertaining to debriefings is important, and we're going to get into this momentarily, but you have to be particularly careful when debriefings are required based on the Competition and Contracting Act and the effect that timeliness has on that. And we're going to get to that momentarily and what it means. With respect to the U.S. Court of Federal Claims, there are no set time limits in terms of when you have to file your protest. Generally speaking, with respect to pre-award bid protests, you're going to want to file them if you choose to go to the Court of Federal Claims before the due date for bids proposals. That doesn't change. Post-award, you're talking about a reasonable amount of time. There's no set time frame, but you don't want to wait too long. Okay, it's important that you move forward as quickly as possible and get your filing in, but there are no set deadlines. Advance the slide. All right, so I mentioned this a few moments ago, SICA stay. So the Competition and Contracting Act, depending upon where you file, will come into play and will have an impact on the agency's ability to move forward. So if you file your protest either with the agency or at the GAO, whether it's pre-award or post-award, it will stop everything as long as as long as it's being filed timely. We'll talk about timeliness in a minute. We have it identified here on this slide. But if it is timely, pre-award, and you're talking about a pre-award protest, the agency cannot make an award without substantial justification. And by substantial justification, what we're saying here, and based on how the law has developed, the agency would have to prove it had an urgent and compelling basis to move forward despite a timely pre-award protest being filed. Post-award, if it's timely, the agency must suspend performance of the contract, meaning it can't move forward, provided the protest is filed within 10 days of contract award, as we say here, or the protest is filed within 5 days of a required debriefing, whichever is later. So you see that 5-day requirement, which differs a little bit from the timeliness requirement generally when we're talking about debriefings. If you want your automatic stay on a post-award bid protest in a situation where there's a required debriefing, just make sure that it's done within 5 days of the debriefing occurring. Okay, so that's very important. And you also want to be careful because you want to make sure that a debriefing is required in a situation where you're protesting. So in other words, if it's a FAR Part 15 solicitation, you're going to have a debriefing that's required. So it's a negotiated procurement. There's going to be a required debriefing at some point in the process, which could then lead to a protest, depending upon what happens at the debriefing, whether or not once that debriefing occurs, the contractor wants to move forward. Sometimes an agency will issue a notification to a federal contractor and tell them, hey, if you want a debriefing, you can have one. Just because an agency tells you that you can have a debriefing, that doesn't mean that it's required based upon the solicitation. It's got to be a required debriefing. And I see this issue arise quite a bit where the timing is missed because someone thinks that a debriefing is required. They're a disappointed offeror, they want to protest, but in fact, a debriefing is not required because under that particular solicitation, it's just simply not. So you have to make sure that there's a required debriefing under circumstances like that, and that you understand how the rules work. And so I always recommend, hey, look, if you're a federal contractor, you better have somebody in your corner who understands what the rules are and who you can turn to help you understand these issues. Okay, next slide. Okay, so what if you're the awardee and your award is protested? What do you do? Well, if the protest is filed at the GAO or at the Court of Federal Claims, you have a right to intervene. And I always recommend that contractors intervene. You have, as I say, an intervention as a matter of right at the COFC, at the GAO. You could even get, or you can even be given the ability to intervene at the agency level, though you don't see it all that often. It's fairly rare. And it's rare because the process is, generally speaking, pretty short. And we'll get into that in a moment. But you want to intervene. And you want to intervene for the purpose of preserving and protecting your award. The agency, generally speaking, will work with you as the awardee if you intervene, and generally speaking, the agency will defend its award. but that doesn't necessarily mean that they will do as good a job as you might do in attempting to preserve your award, and the perspectives could be a little bit different. So my recommendation is to always intervene. Now, you don't have to, as we say here, you don't, but the chances are you're going to want to, so you can be a part of the process, understand how the agency is going to defend its selection process, and you're going to want to probably assist the agency in doing that. Okay, advance the slide. All right, let's talk a little bit about what happens when you go to each level. If you go to the agency, what happens? So you file an agency level protest, and it's a pretty quick and easy process. There's not a lot of process itself involved. You can initiate one of these by letter or even an email, and it's fairly informal. So it's pretty cost effective. When we started talking about this about 20 minutes or so ago, I said, okay, if you're going to answer the question, should I file, you have to also ask yourself, okay, can I win? What's it going to cost? Well, if you go to the agency, it doesn't cost very much, and it's easy. The question you have to ask yourself is, can you win? You're protesting to the party that allegedly made a mistake, and you're asking that party to effectively undo something that it did. It's a harder win, if you will. Very cost effective, but it's more difficult to win. Generally speaking, these decisions come out within 35 days. That's what the FAR requires, and it also says that the contracting officer should provide a well-reasoned decision. Sometimes you get one, sometimes you don't. Generally speaking, that 35-day period is maintained primarily because if you've done everything timely, you have a sick stay in place, and the agency will want to proceed. So it's an extra incentive for them to move forward. The types of relief you can get a correction of a solicitation deficiency if that's the nature of the problem. And that's where you're going to find your most bang for your buck if you're going to go to the agency. If there's some sort of obvious problem with the solicitation itself, you may want to consider an agency protest, and that's where I found them successful in the past. Hey, there's a problem with the solicitation, Mr. or Mrs. Contracting Officer. It really doesn't make any sense. You may want to fix this before we go any further. And if it's obvious, then that's your best shot at winning an agency protest. You're generally not going to get a contracting officer to do much more than that. Advance the slide, please. So at the GAO, which as we identified earlier is the most popular of those options in terms of where to protest, you're going to file now using the GAO's electronic filing system. It's new within the last, I'd say 6 months or so. There is a filing fee. It's a $350 filing fee, so that needs to be taken into consideration when we think about, okay, what does it cost and can I win, right? So you're going to be filing using this new electronic filing system. We see here who can file, and we talked about that a little bit earlier. You have to be an actual prospective bidder with a direct economic interest. One thing to keep in mind, and this doesn't change whether you go to the agency, even though it's a little bit different there, but whether you're going to the GAO or the Court of Federal Claims, this great deference that we identify here to the discretion of the agency has to be kept in mind, because the can I win aspect of this, that's where this comes into play. If it's a completely discretionary act of the agency, it's going to be much more difficult to prevail than if you can find something that's more in the way of clear error. And so that's something to consider as you're thinking about whether to protest and that sort of thing. One thing to keep in mind for protests that involve proprietary, confidential, or source selection information, parties can request that a protective order be put in place, and that's common. And why is it common? Because if it were you whose award's being challenged, you don't want your competitors to see what you put in your proposal. And you can prevent that by asking for a protective, if there's a protective order in place. And many times a protective order will end up being in place. I would say it's nearly every time, pretty much anyway. And if you have counsel, which is advisable, your attorney will be able to get admitted under the protective order and see this information. Now, it gets a little tricky because the attorney your attorney isn't supposed to tell you what he or she has seen in an awardee's proposal, for example, if you're the protesting party. But there are ways that attorney and client can communicate short of the attorney providing confidential or proprietary information to the client. For example, they can tell you whether or not you still have grounds to move forward once that information has been provided. So that's something to keep in mind as part of this protest process, if you will. Advance the slide. After you go to the GAO and the filing is in place, the agency has 30 days to issue an agency report, and then thereafter, once the agency report is issued, there are 10 days to file comments to that agency report, as well as file supplemental protest grounds if those arise based upon what has been revealed as part of the agency report. Keep in mind that as part of this process, if comments are not provided following the issuance of the administrative record, and the protest will be considered withdrawn. You can always withdraw your protest at any point in time, but if you are going to the GAO, understand that if you don't issue comments to an administrative report, that can be problematic for you. Protests are required to be resolved within 100 days by the GAO, and the GAO issues reports every year. One of the things that it does comment on is whether or not this 100-day period of time is adhered to. For fiscal year 2018, there were approximately 2,400 protests that were issued, and every single case that 100-day period of time was adhered to. Just so we're all clear there. So that 100 days is 100 days. Advance the slide. So what can happen? We talked about the fact that once you go to the GAO, you can withdraw at any time. Corrective action can happen, and it happens quite a bit. As part of the GAO's reporting to Congress every year, they report on what they call a success rate. Okay, the success rate for fiscal year 2018 was 44%. And 44% takes into consideration how many times a protest was sustained and when an agency took corrective action. So 44% is pretty good. And for, say, the last 4 to 5 years, the success rate has been somewhere between 40 and 50%, somewhere in that range. So it's not bad. Now, most of that is the agency taking corrective action. When they take corrective action, what they generally do is they recognize they made a mistake, and they go back to the drawing board and reevaluate. All right, so it gives you a little bit of, yep.
Sorry to interrupt, but we were actually out of time for today, so I'm just going to fast forward a little bit. Thank you for all of your information. Hopefully we'll be able to touch back based on this in our 2019 webinar series. And thank you for everybody who joined us. And if you have any questions or want to talk further about the rest of the presentation, please contact Ed directly. And right now, right after this webinar, we are covering the GSA rate increases to EPA. So thank you again, everybody.